Hey, good evening, everyone. This is Stacy Lake with my special edition Let's Talk Jackson, where I'm going to go over the events that happened in the case against Jackson County on day one and day two of trial. Before we begin, I want to again give a disclaimer. While I am an attorney who specializes in civil and commercial litigation, this is not a legal opinion, and I am not providing legal advice in this podcast. Also, the the transcriptions that I provide and my opinions of what the witnesses testify to should also not be taken as absolute fact. I am not a court reporter. I did not get the official transcriptions of the witnesses' testimonies. These are notes that I took during the trial, and so my notes are prone to error. However, I did go to the Jackson County Courthouse, and we'll get into later the switch to the Clay County Courthouse. And I did witness the first 2 days of trial. And this special edition of Let's Talk Jackson is specifically going to cover the witness testimonies from day one and day two of this trial. Now, before we get specifically into this case, I want to go over some issues with the trial and also give you another disclaimer. I am withholding my official opinion of what's going on during this trial until after the case rests, because I do not want my opinions about the attorneys or about the status of what I think the case is going to be known until after the case rests. So when the case rests, it's basically after the state and the county put on evidence, and the judge takes that evidence, and then it'll take a little bit of time for the judge to issue their opinion. So after the state and the county rests their case, I'm going to do another Let's Talk Jackson, where I'm going to go over more specific opinions that I have of what was going on the trial, what I thought about the defense, what I thought about the plaintiff's case, so on and so forth. But in this edition, I'm specifically just going to talk about the witnesses' testimonies in day one and day two of trial. But one of the issues that I have with the trial is, first, there is a severe lack of media coverage in this case. During day one and day two of trial, only Angie Racono of KCTV5 was actually in the courthouse reporting about what was going on, and KMBC 9 News. No one else was there. KCUR wasn't there. The Kansas City Star wasn't there. And that's very concerning, because who is reporting this historical case to our local residents? Only Angie Racono and KMBC, which I find is ridiculous, because historically speaking, this is the biggest case in Jackson County history, and every single local reporter should be there to tell their viewerships about what's going on in this case, because this case affects every single owner of property in Jackson County currently. Oh, hi, Dana. Dana states, I thought media wasn't allowed at the trial. No, media is allowed. In fact, media can come in to take pictures and to do live communications. As you know, during the trial, I've been doing live tweets of my transcriptions of the witnesses' testimony. So media is 100% allowed at trial. When it comes to the American judicial system, media is allowed at any trial, because all of our trials are public, and so anybody can go into the trial, including the media, or witness the trial, including the media. And so I just think it's a shame that our written media sources like KCUR and the Kansas City Star just are not there. And they have not reported or focused on this issue that has severe historical implication for Jackson County. Also, I want to talk about what happened on day 2 briefly. During day 2 of trial, the water in the Jackson County courthouse stopped working, and therefore they had to stop the trial. Like in the middle of trial, they had to stop the trial and then move the trial from Jackson County to Clay County, which was a huge effort because on that day, the state had probably at least over 8 witnesses there. Most of them are civilian witnesses there. Some handicapped people that had to then move from Jackson County to Clay County, which is around a 30-minute drive, which again goes into the fact that our county courthouse is in utter disrepair. And there is another issue there where right now there's $69 million that the Jackson County government currently has that they can spend on any single project that they have for years, but they're refusing to invest it in our infrastructure. And I found that this whole situation with the water was just embarrassing because a lot of the attorneys and witnesses that are from different areas of Missouri were just shocked that the courthouse had such a maintenance issue during this time. And so that's also one implication we need to look at it during this trial. Finally, yes, and I agree with you, Laura, we need courthouse renovations now. And finally, I do want to give my opinion right now on the judge of this case. The judge on this case is a Clay County judge. And I just want to tell everyone that this judge is level-headed. She is, in my opinion, she's making rational, well thought out decisions. She's really considering every aspect of this case. And even all the people, well, I shouldn't say all, but the majority of the people in the courthouse really like her. They think that she's being fair. They think that her temperament is great. And she has been moving mountains to make sure that this case is processed on time. As you know, the next trial date is July 8th. And the judge has stated that that's going to be it. It has to be finished on July 8th. Now, because of the whole situation with them having to move courthouses from Jackson County to Clay County, maybe on July 8th, if they need more time, they'll extend the time, or maybe they'll add on an additional day. But as I'll state at the end, the state only has 2 more witnesses to put on. That's Gail McCain Beatty and Preston Smith. And after that, the state's going to rest their case, and the Jackson County defendants are going to start their defense. And after that, the case is going to be rested until the judge makes her decision, which a judge can take all the time they want to make their decision. But like I said, after the judge rests her case, I will be coming out with another video with my viewpoint on what's going on in trial, who do I feel is doing a good job, where do I feel like the opinion is leaning in this trial, what are the important points in this trial, etc. But let's start on this presentation. So the first witness that the state called to the stand was a witness named Larry Jones. Now, Larry Jones is a manager for the State Tax Commission, and he basically was testifying as to whether or not the Jackson County property tax assessment was complying with the state law. And so he states he was basically going through the process of a correct assessment or reassessment. And he stated that when it came to a reassessment, it starts by a parcel by parcel review. And that if the assessed value increased by over 15%, the county is required by statute, and the statute that we're referring to here is 137.115, to send out the notice. And this notice must state that first, that your assessed value was increased by over 15%. And the way that they'll show you this is they'll have your 2022 assessed value and then your 2023 assessed value, and then they'll have the percentage increase. But they're supposed to first notify you that your assessed value increased by over 15%. And then second, that by statute, a physical inspection must be performed. And they're supposed to give you notice of when this physical inspection is going to perform. And also, they're supposed to provide you with statutory notice that if you want, you can have an interior inspection with the physical inspection. As we all know, after this property tax crisis occurred, we didn't know about the interior inspection until after the fact, until they were offering the interior inspection. We did not receive proper notice, and that's what Larry Jones was really going into. So he also went into how property is comparable to other properties in determining to what a fair assessed market value was. And so with his testimony, he basically stated that the 2023 reassessment notices that were sent out did not comply with the statute. And he again stated that first, the notice was undated, and two, that they failed to have a method, or they when they sent out these notices, there's no method to tell when it was sent. The county says that these notices were sent I believe on May 31st and June 15th, but because of the nature that the county sent these notices out, there was no way to tell when they were actually sent and when they were actually received because they were all undated. So the next witness that was brought to the stand is a witness named Jeffrey Smith. And Jeffrey Smith is currently a part-time employee that works with the State Tax Commission, but he had Larry Jones' position in 2022 and 2023. And so Jerry Smith's testimony is twofold. First, he was going to testify as to whether the 2023 property tax assessments were proper. But second, he was also testifying to provide his own personal experiences with the 2023 property tax assessments. And again, just to state, Jeffrey Smith had Larry Jones' position in 2022 and 2023, which was he was a manager for the State Tax Commission. So Jeffrey Smith basically starts out with his own interpretation of 137.115. And he states that, again, that if a property's assessed value is raised over 15%, Jackson County government must first notify the owner of the increased value. Then they're supposed to conduct a physical inspection. That's when they provide notice of a physical inspection, and then they're supposed to perform the physical inspection. Jeffrey Smith stated that it was either March or April of 2023, the State Tax Commission, it was when the State Tax Commission first had multiple concerns about the 2023 property tax assessment. And it wasn't until September or October that the State Tax Commission actually reached out to Jackson County and asked for information of their assessed values. He identified three big concerns that the State Tax Commission had with the 2023 property tax assessments. First, he stated that the property owners did not get physical inspections on their properties. Second, that the impact notices, and I will be saying impact notices quite often in this podcast, The impact notices are basically the 2023 reassessment notices. It's the official reassessment notices that most of us received around the June 2023 time, that officially states what our assessed values increased, or what they were increased to. But he stated that the impact notices were not sent out or were not received on time, and that the impact notices within the impact notices, it was not statutorily compliant. And third, he stated that this is when the State Tax Commission learned that the Board of Equalization had issues with their hearings on the increased assessments. So on his first point of that the property owners did not get physical inspections on their property, he first says that he goes back to the impact notices. He states that the impact notices were untimely. So he first goes into the fact that the impact notices were supposed to be sent out by June 15th, but he then states that when it comes to physical properties that have their assessed values to be increased by over 15%, these impact notices have to be sent out earlier because they're supposed to notify a property owner of these increased values so they're able to get the physical inspection and the interior inspections. He again states that these impact notices, either the property owners did not receive them or they did not receive them on time. Next, he states that there's no evidence that the notices, and so we're talking about the first notice that goes out to the Jackson County property owners. So I'm actually going to just quickly go try to make this a little bit clearer so we're all on the same page. So what I brought up here is this is the auditor's report, but this is basically what he's referring to. So this is the notice that Jeffrey is talking about as to the first notice that should have been sent out to property tax owners. And when he's talking about impact notices, this is what he's talking about. He's talking about the official 2023 reassessment notice. Now, if we go back to the first notice that was supposed to send out, this is the one that Jackson County sent out. This isn't the one that he would state actually complies with statute 137.115, but he states that the properties whose assessed value increased by over 15%, that this impact notice should have showed the assessed value increase, which it didn't do, but that they were statutorily required to tell the property owner that a physical inspection was required, the date and time when the physical inspection would actually happen, and that they had the right to also request a physical and interior inspection when Jackson County comes out to do their physical inspection in order to determine the assessed value of the property. And Jeffrey Smith basically said that this did not happen. So when he says that there's no evidence that notices were ever sent out to owners that a physical inspection was to be completed, he's referring to those two notices, because he basically is referring to Gail's testimony, where Gail stated in her deposition that the county did physical inspections before the property values were increased, before the property owners had noticed that their assessed values were increased by over 15%. So after reviewing that testimony, Jerry Smith's like, well, here we have the evidence here that shows that that there was no physical inspection done after the property owners received notice that their assessed values on their properties were going to increase by 15%, and therefore they did not comply with the state statute. On the second point, that the impact notices were not sent or not received on time, he basically states that the county assessor's official books, and these are the official books of what the values are supposed to be closed by July 1st, 2023. However, he again states that when it comes to properties whose assessed values increase by over 15%, it has to be sent out well before then. And if you watched my prior video on this case, this goes into the state's argument that the due date for these notices were in fact April 23rd, 2023, and not June 15th. And on his third point, that the BOE had issues with their hearings on the increased values, he basically was referring to the long wait times. He stated specifically that he's never seen such large increases and believes that over 70% of the properties in Jackson County had their assessed values increased. And he also stated that 1 out of every 6 parcels in Jackson County appealed, or parcel owners appealed. He also stated that he never directly notified Jackson County of any of the deficiencies before the 2023 property tax assessments occurred, because the state tax commission simply didn't have information of what Jackson County was doing at the time for them to provide them notice. So during Jerry Smith's testimony, the judge had a question. And so when judges have questions, these are times where we really have to, focus on what the judge is asking for, because the judge's question is kind of going into, or possibly, okay, let's keep this PG, possibly could be going into what the judge believes are very important to their opinions. And so the judge, and this isn't the exact question that the judge asked, this is my paraphrase, but the judge asked, where was the information that the physical inspection was performed? And in asking this question, she actually had an exhibit that was a example of what the of the documents that would be given to the BOE level to show that a physical inspection was performed. And so Jerry Smith was looking at the information, and Jerry Smith responded that the only information that he had to show that a physical inspection was performed on the specific property that was this exhibit was the information that was provided. And again, the information that was provided to a judge was an example, like a property example of what would be given to the BOE or the state tax commission to show that a physical inspection was performed. So then the judge responded that there was only a photo included in this packet. And Jerry Smith's response was that then when the photo was taken would be the only evidence of the date of when the physical inspection would have taken place. So when asked what date was this photo, Jerry Smith pointed out that the date was June 21st, 2021. Now, this date I have here, it could be wrong. I could have misheard, but I believe it was definitely 2021. Regardless, it was after the date was after, or sorry, was well before when an inspection should have taken place. Okay. Jerry Smith additionally stated that on those documents, it did not have the name of the inspector, the date/time that the inspection occurred, and the extent of the inspection was not included when it was statutorily required in the impact notice. So hold on a second. So when he's saying in the impact notice, he's referring to this piece right here. So he's stating that in the official 2023 reassessment notice, when they're showing you your official increase, it was supposed to show you evidence that the physical inspection actually occurred. And in that, it was supposed to show the date and time, the name of the inspector, and what the inspector did, which the extent usually means that they measured the house or whatnot, right? And again, this is the notice that should have been first sent out to the property owners who had their assessed value increased by over 15%, stating that if that their assessed value was going to increase by over 15% and that a physical inspection was required and that they were going to perform a physical inspection, which the majority of us know did not happen. So the reason why I believe that this could possibly be a good sign, but I'm really not going to go into it until after the case rests, is because this is giving a signal that the judge is really looking to the statutory question on this case as to whether or not the Jackson County government actually complied with the statute when it came to this 2023 property tax crisis. The next witness that came on, and I would argue that he was by far like top 3 strongest witnesses for the state, was a person named Kennedy Jones. Kennedy Jones was a hearing officer for the Board of Equalization until October 2023. And in his occupational life, he was a real estate broker for over 30 years. But he was unfortunately fired from his position as a hearing officer in October 2023. He believes that he was wrongfully terminated, and we're going to get into it. So, Kennedy Jones goes into what a hearing officer is and what they're supposed to do. So in going into the process of hearing officers, he states that hearing officers are supposed to be separate from the assessment department. Now keep that in mind, okay, that the hearing officers are supposed to be separate from the assessors department, because remember, the hearing officers work with the Board of Equalization. They do not work with the assessment department. He stated that his process would be that he would be given a general information sheet of paper about the property and a memorandum of settlement that was also given to the property owner. Mr. Jones would look at the pictures of the property and the evidence that the property owner would provide, and then look to a comp sheet to see what the county did in order to explain to the property owners why the county valued the property the way that they did. Jones also testified that he would also run his own comps and come to a conclusion as to what he believed the true assessed value of the property would be. He would discuss the property with the property owner, and then he would also discuss the property with the assessment department. And then after he discussed the issue with both sides, he would come to a conclusion of what the assessed value would be. And then he would provide his recommendation. And if the assessment department and the property owners agreed to his assessed value, then the matter would be resolved. If they reject it, they would have a formal hearing with the Board of Equalization on a later date. Now, one of the reasons that Kennedy Jones stressed the importance of his job, besides resolving cases early, is that they would use his own independent, and we're going to get into this, independent valuation as evidence in the BOE hearing. And so that's why it was so important to make sure that he was doing his evaluations correct, because in a lot of cases, the BOE could make a determination, could just accept his valuation of the property and reject the assessors and the property owner's assessment of the property. So that's why I said it was so important. So this is his testimony. He stated that the majority of the disputed property value assessments were egregiously higher than what they should have been. He stated that During the process of these informal hearings, he started to see a pattern of errors in the comparables. He started to use the phrase invalid comparables, and invalid comparables. So invalid comparables he calls as invalid comps, okay? And he states that invalid comps were comps of properties that did not statutorily match the subject property being appealed. So what he's talking about is when and everybody here probably knows what comps is, but usually when determining the value of a person's home, they take properties that are supposed to be similar in square footage, within a 1 mile diameter, has a similar amount of bedrooms, baths, and is in a similar state of condition. And they use the value of that property in order to determine what the value of your home should be. And Kennedy Jones stated that Tyler Technologies used invalid comparables, meaning that they were using comparables that were not similar to the square footage, number of bedrooms, the area of the subject property. He stated that the county would not have the comparables of the subject property done before the hearing, and they would be running comparables at the time the hearing would start, which is massive because you have to ask yourself the question, how did they determine the assessed value when they sent out the notices, right? If they're running comps that day. He also stated that there would be cases where a house would be identical to the subject house and the county would reject that house as a comparable. He testified that the assessment department and Tyler Technologies were defrauding the taxpayers because they were using invalid comps and using every means possible to discredit property owners who were providing comps. And this one was crazy, and I'm going to actually show you a video that he did for KMBC. But he also stated that a Tyler Technology employee told him to add a standard 10% on top of his own assessed value, and when he asked why, they didn't provide him any evidence to support why he needed to add on that additional 10%. Kennedy Jones then testified that the county and Tyler Technologies tried to influence Kennedy Jones. He stated that Tyler would come to him and told him how to manipulate the numbers to come to the assessed value. Kennedy Jones stated that he told them that he wouldn't do this and that this wasn't right and that this was the basis of his termination. He stated that once he started to reject county and Tyler Technologies undue influence or intimidation, trying to force him to change his valuations, that the environment in the work or in the environment in the informal hearings became hostile and that he was fired soon after that. Kennedy Jones also stated that Tyler Technologies and the county used fear and intimidation methods on him and other hearing officers to force them or influence them to change their methods and decisions. And Kennedy Jones stated that this has never happened before in his experience as a hearing officer. He also testified that the county raised the taxes so high because they knew that a large number of people would not contest the values. And then he goes into the emotional distress that he felt during this property tax assessment. Because remember, he was a hearing officer during this whole entire debacle. He referred to three different situations. First, he talks about his experience with Gail. He stated that she directed Kennedy Jones to do things that she wanted to do. Jones stated that Gale told him that the BOE relied heavily on the hearing officer's determinations. And because of this, that's why Gale wanted his assessment values to be what she wanted them to be, because she knew that they heavily relied on his determinations. He stated that there was a case where a property was valued way lower than what a property was valued, or the property's assessed value should have been valued way lower than what it was assessed at. And he stated on the witness stand that every single hearing officer agreed with him that this property was assessed too high. However, the other hearing officers were too afraid to bring up this issue with Gale. So he decided that he was going to do it. He went into Gale's office and asked for Gale's approval on this memorandum of settlement. Gale refused, called him cray. And yes, I'm saying the word cray as in crazy. Called him cray and yelled at him to leave her office. He then talks about an experience that he had with Ron Jurgensen. And Ron Jurgensen, I'm probably saying his name wrong, but keep with me. He's a part of the legal counsel of the county, but as an independent contractor and not as an employee of the county. And he's being paid by the county to provide independent legal services and representation to the Board of Equalization. So he stated that Ron created fake complaints about him and used these fake complaints to terminate him. Oh, and Megan, when you say, is there a link, can you please define to me a link to what? Thank you. But Ron stated that Kennedy Jones stated that Ron created fake complaints about him and that the Board of Equalization used these fake complaints that Ron created in order to terminate him. And he also stated that the BOE, the Board of Equalization, owes him money, approximately $8,000. And he also stated that other hearing officers are also due money, but they haven't received it. Because we have to remember, these informal hearing officers were working overtime during lunch hours, and that they should have been paid during those hours. And he stated they were never paid. Finally, and this was the funniest part of the day. Okay, there's hardly ever a humor in the court, but this was really funny. I'm going to explain it to you. He talks about his experiences with the county counselors. So these are the county attorneys. He stated that and this was during the cross-examination. The attorney for the county asked him, did you ever tell or provide notice to the county of the issues that you were having with these informal hearings? And he stated that he's been emailing the county attorney about his complaints, but the county attorney did not get back to him. And so the county attorney was like, which county attorney were you emailing? And so I don't know the name, but let's just say he was emailing a person named Todd Smith. Okay. And so he says, I've been emailing Todd Smith. Remember, this is not the name. This is a name I'm creating. And the attorney that was cross-examining him at the time pauses, turns to the judge and goes, Your Honor, I just want to state I'm Todd Smith. And I responded to those emails. Which everyone was laughing. And for me, this was crazy because and I'm going to get into this after the case rests, but this is kind of going into a gray area where the attorney that was cross-examining Kennedy Jones is in fact a witness to this whole entire thing. And so there was an argument there. The state of Missouri didn't raise it because probably just didn't care to, but there's an argument there that that attorney is a witness in the case and should have recused himself at that time. But that wasn't brought up. But I thought it was hilarious, and the audience thought it was hilarious that the cross examiner became the witness. So that was kind of funny. So overall, Kennedy Jones testified that it was unfair that the assessor increased the values using invalid comps and implied that the assessor monetarily benefited from the increased values. So, in order just to show you something, after this, after Kennedy Jones left the witness stand, he then did an interview with KMBC, and I'm going to run you that clip right now.
Another witness taking the stand, Kennedy Jones, a former hearing officer, fired after he says he was asked by the head of Tyler Technologies to add an additional 10% on top of every value already assessed. He refused.
They brought these outsiders in here, raising our property taxes, and they were benefiting from it because their salaries was based on how much money they could raise the taxes.
Jones urges taxpayers to not let this rest, calling for change as the next tax cycle approaches in 2025.
I know your station says, hey, you hold the powerful accountable. Let's hold them accountable. Let's hold them accountable.
The state is asking.
Yeah, that's all that Kennedy Jones is asking for here is accountability. Oh, hold on a second. Sorry, that's all that Kennedy Jones is asking for here is accountability. And so he was actually a very great witness for the state. There was a time where the county attorney was really pressing him on his knowledge, and he had like the county attorney's cross-examination actually made him seem like a better witness because Kennedy Jones had the statute 137.115 memorized. He was quoting sections from that statute. You could tell that he was very experienced. He had a deep understanding of property valuations, and his demeanor that he had during the trial came off as very sincere. And I think he was a very persuasive witness, a great witness for the state in general. Oh, and thank you, Gina. So the next witness that was put on the stand is a witness that probably some of you guys know. His name is Lance Dillenschneider. He ran for Jackson County legislator in 2022, but he's also known throughout the community in Lee Summit. He is a former Board of Equalization member, but he also is a builder, a real estate broker, and a subdivision builder. He owns over 37 different properties, and so he was testifying on two fronts. First, he was testifying as to what the correct process with the BOE would have been in order to appeal this, and second, he was testifying to his personal knowledge as to what the 2023 property tax assessments were to a person who's actually going through the process. So Lance basically stated that the 2023 property tax assessment was the 2019 property tax assessment on steroids. And he stated that the county made it impossible for the entire process to be fair. He stated that he witnessed property owners having to wait all day before their hearing would be held, and that this process of basically scheduling a property owner, and we're talking about the informal hearings, to be heard, and then having them wait 5, 6, 7 hours before they're actually heard, discourage property owners from continuing with the process to appeal their assessed values. So we're talking about going from the informal hearing to the formal BOE hearing and eventually to the State Tax Commission hearing. He also stated that by the county postponing the Board of Equalization hearings, that it now has made it virtually impossible for property owners to participate in the appeal process. So if you didn't catch my first video, the Board of Equalization since December 2023 has postponed their hearings, and now they started up hearings again, but it's minimal hearings. It's not like the hearings that we had in 2023. And the state is arguing that it's going to be virtually impossible for the Board of Equalization to finish these hearings when they're required to, or on their last possible hearing date, which would be March 1st, 2024. Lance also stated that he wasn't able to get an appointment to have a hearing with the Board of Equalization, and that he actually had to hire a tax consultant to get an appointment for him. And that when he had this tax consultant get a hearing, that before that happened, that the county actually made him attend 4 informal hearings. And we're going to get into the other witnesses' testimonies, which are individual property owners detailing their process. But you have to keep in mind the facts that these people are saying, what's going to be repeated. And during the court, one of the things that were repeated, besides the long wait times, is the fact that these people didn't have one informal hearing, then go to the BOE to have a formal hearing. They had 1, they had 2, they had 3, they had 4, and they still haven't had their BOE hearing yet, which usually you have an informal, and if you reject it, you're sent straight to the BOE. But in this case, as Lance is detailing in his testimony, that didn't happen. Lance also states that he recognizes his position of privilege, that an average person isn't able to hire a tax consultant to do this for them, and that if he didn't hire the tax consultant, he would have never had his BOE hearing in the first place. Lance stated that he would be on the phone waiting for over 3 hours trying to talk to a county official about the property tax assessments, but no one would answer the phone. And he states that as a real estate broker, he has had prior clients who try to sell their homes, but had a difficult time due to the 2023 property tax assessments. Because remember, when the assessed values when the assessed values were released, that means that if a person's assessed value increased, the required mortgages payment per month would also be increased. And so say if you had a house, you bought it for $300,000, and say it was assessed at a $200,000 level. So instead of paying, let's say, $2,500 per month, you would actually have to be paying like $4,100 per month to account for that increase in assessed value. He stated that that would prevent people who are considering purchasing a property from actually going through with the purchase. Lance also stated that he observed multiple instances with improper processes with the appeal process. He stated that an average person should not have to go through a sunshine law request process in order to get the comps that the county did on their property, which I actually agree with. I think if the county increases your property value, they should also be directly providing you all the evidence that they're going to use to increase your assessed value. It shouldn't be on the property owners. It shouldn't be on the property owners to make that sunshine law request, because the average person doesn't even know how to make a sunshine law request. They don't even know what a sunshine law is. He also stated, and this is going to be stated on multiple occurrences, that he had to make repeated sunshine law requests in order to get his property. And also, he stated that sometimes the county would use comparables from different cities in order to justify their values, which is massive, because we all know in Jackson County, 2 cities are not alike. You will not win an argument saying that, for instance, like Grandview and Lee Summit are alike, or Oak Grove and Green Valley are alike. But apparently during this assessment situation, they were using houses from different cities to compare their values with, which the average person without any real estate experience would know that would lead to improper comparisons. Lance also stated that the 2023 property tax assessment created crippling consequences. He stated that he has personal knowledge that there are a lot of elderly people that are making the decision to take medicine or pay their property taxes, which I can attest to, especially in the 2019 property tax crisis, that when they increased the property values by so much and provided little recourse for people in Hyde Park and people in Jackson County to lower their property values, there were a lot of elderly people that had to lose their homes. And there was a lot of elderly people that had to make the decision between staying in their house, paying the increased values in property taxes, or getting their medicine and food in some cases. In the cross-examination, the county owner basically had Lance state that he had over 35 properties, but when it came to his specific residential home, it took less for a month to have his home property value lowered and for him to accept a valuation from the county. But he states that when it comes to his other properties, that it took all year in order to get those resolved. And finally, Lance was talking about his opinion on the county using Tyler Technology as its provider. And he stated that Tyler Technology does the county assessments for many other counties, and that it's owned in part by BlackRock, who has an incentive to make home ownership impossible for the individual. So now we are on day 2 of the trial. And the first witness that was called to the stand was Sean Smith. Now, before Sean Smith was called to the stand, there was a massive motion hearing. So this motion hearing was whether the testimonies of Sean Smith and Preston Smith could be included in this case. The county was arguing that Sean Smith's testimony must be excluded, and also Preston Smith's must be excluded for various reasons. But when they tried to bring this up on day 1, the judge basically made the comment that there was no written motion about this. And so the county provided a written motion at like 1:30 a.m. that morning. And they wanted to take it up that day, but then they agreed that they would allow the state time to fully brief that motion, and they would take it up on July 8th. However, when Sean Smith was called to the stand, so this is, I'm trying to get, this was when day 2 started in Jackson County. And that's when the judge was like, okay, what if we do this? Sean Smith can go on to the stand, and I will take the arguments. I will take the arguments up on July the 8th. And if I determine that Sean Smith's testimony should be, and Preston Smith's testimony should be excluded, then I will exclude their testimony, which judges can do when it comes to bench trials. And they're like, okay, that can happen. So then when that was decided, we had the water issue in Jackson County, and we had to move all the way to Clay County. And so when we get to Clay County, and this happened after the state, and I'll get into Sean Smith's testimony, after the state direct examined Sean Smith, the county then brought up the motion again and was like, Sean Smith's testimony needs to be excluded. It's prejudicial, blah, blah, blah. Mostly because Sean Smith is a defendant in this action. And there's also a sense of impropriety with communications that Sean Smith might have had with the state attorney's office. And I'm going to get into that after the fact, because that's when all the pleadings will be filed and there'll be the hearing that'll be held. And so I'll be able to give you more context as to what the county and the state is arguing in this motion hearing. And so when that was going on, the state was like, you know what? We don't need to respond to your motion in writing. Let's take up the oral argument right now. And so when that happened, the county attorneys looked to the state attorneys and was like, we don't want to have an oral argument today. And I'm sitting there like, what? Like what's going on? So the county attorneys were like, we don't want to have the oral argument. We're fine with delaying this decision until July the 8th, but we don't want to cross-examine Sean Smith. And so then the judge was like, well, you'll still be able to bring Sean Smith as a witness in a direct, but this is the time to cross-examine. And the county was like, well, we're just going to waive our cross-examination, which I'll go into detail on my opinion on that decision, but that's what happened. So let's get into Sean Smith's testimony here. Hold on a sec. Yeah, Aaron, I know a lot of people that had to sell their property too because of these property tax assessments. And I also think that it's extremely ridiculous. Thank you for your comment. So Sean Smith, for people who don't know, he is the current Jackson County legislator of the 6th District. And he is also being sued as a member of the Jackson County legislature. So remember, in this court case, it's the state of Missouri that's represented by the state AG's office and the state tax commission versus the Jackson County executive, the Jackson County legislature, which also includes Sean Smith, the Board of Equalization, the county assessor, which is Gail McCain Beatty, and Tyler Technologies. And as I stated before, Tyler Technologies is not on trial. They requested a jury trial that's going to be heard next year. So their trial isn't until next year. But the Jackson County trial via bench trial is happening right now. So this is Sean Smith's testimony. Sean Smith basically stated that he believed that Jackson County violated state law with the property tax assessment. He stated that Gail has made multiple statements about her not being confident with the 2023 property tax assessments, stating statements to him like, we bit off more that we can chew regarding the 2023 property tax assessment. Sean Smith stated that he heard hundreds, and I believe Sean on this one, because if you guys were not following like the Jackson County property assessments Facebook groups, or all the Facebook groups that are going on and all the media going on, then you guys wouldn't know Sean Smith has been deeply involved into answering people's questions as to the property tax assessments, and also providing solutions to people who are having problems with submitting their appeals with the property tax assessments, or getting scheduled hearings with informal hearings or hearings in front of the BOE. And so I believe that, yeah, he's heard hundreds, if not thousands, thousands of people that communicated to him of the large increases. Sean Smith also stated that there was problems with that people had with their ability on how to get the appeal started. He testified that there's still technical challenges with the appeal process, and mostly it has to do with scheduling the informal and formal hearings regarding the BOE. And remember, the BOE is still postponing appeals hearings. There's still hundreds / thousands of people who have their property still in the appeal process that still has not had a hearing with the BOE currently. Sean Smith also stated that that he was elected to serve the people. He stated that the concerns from the people combined with the concerns that he heard from Gail McCain Beatty made him worried. He stated that he passed resolutions to ask the county executive to correct the errors in the assessment process. He stated that he witnessed individuals who had large increases in property values. And so this is when he's talking about his first, when he initially started to see the problems with the 2023 property tax assessments, when people were first talking to him about their large increases. He stated that he looked into his own neighborhood to see how the property tax assessments were done in his own neighborhood, and he witnessed 30 to 40% swings in assessment values in his own neighborhood that again triggered his concerns. Sean Smith then stated that he recommended a remedy of setting aside the 2023 property tax assessments. He additionally stated that no reasonable person could look at this assessment and state that it was reasonable, and that in addition to that, there are thousands of people that are unable to appeal and that cannot appeal right now. He also stated that there were various issues with phone calls dropping, and that he himself went into the assessment department and was asking for data, specifically how appeals were filed, how many appeals were resolved, how many appeals were pending. And he stated that he was denied access to this information. When talking about going to more about the technical failures, Sean Smith stated that the electronic mailing system that was supposed to email the residents of when the informal or the formal hearings were to take place would have multiple errors. He stated that these emails would not be sent out or have errors in their delivery. He also talks about the place that the informal hearings would take place, which is the 1300 Washington building. He states that at the time, the building was not finished, and due to this, there was large lines and large wait times for people to hear their appeals. Sean Smith also stated that people who were over the age of 65 years old were disproportionately more likely to have extreme property tax increases, and that this was concerning because their health would be more affected with the long wait times, lack of access to food, water, and medicine. Because remember, these people would show up at their scheduled times, but in most cases, these people are alleging that they would come up to their scheduled times, but they would have to wait 4, 5, 6 hours after their scheduled time to have their appeal heard, right? And this is their informal hearing. And so, asking a person to prepare, or those people that are coming for their informal hearing on time are not prepared to sit there and wait for 4 to 5, 6 hours. And so this is Sean Smith going into what methods were used to discourage property owners from continuing with the appeal process. Sean Smith also testified that Tyler Technologies showed him the software that they used. And Sean Smith states that the accuracy of the forecasting was not precise. Now, when Sean Smith is talking about this software and the accuracy, he basically makes it clear to the court that before he was a Jackson County legislator, that he actually was a business consultant and that he would work with other large corporations in order to make projections and forecastings for products. He had this great example that I'm going to explain right now. He basically said, hey, what if my client, for instance, was Mattel? He was explaining that Mattel has or there's forecasting software out there that could accurately predict how many Barbie dolls Mattel is going to sell within a year. However, when you ask that software to specifically forecast how many dolls are going to be sold on December 27th, it's not going to be accurate at all. And so he used that example to showcase why Tyler Technologies software was also inaccurate, because he stated that while he believed that Tyler Technologies' overall forecasting as to what the total assessed value of Jackson County was could have possibly been correct, when you're looking at the individual parcels, it was completely wrong and completely off. Sean Smith also said that that the errors that he listed, that I stated before, are still persisting to this day, and that he views that the position of the assessment department conflicts with his. And he states that he states that the assessment department has been defensive towards him instead of solving or resolving the problem. So when he's talking about the resolutions pertaining to this case that the Jackson County legislature passed, he's referring to 4 different resolutions. So the first resolution basically states that, and these are all resolutions that the Jackson County legislature passed. The first resolution states that the intent and purpose of the resolution was to tell the county executive that the Jackson County legislature witnessed enough evidence to see the errors in the assessment process, and that the Jackson County executive needed to correct him. Because remember, in the Jackson County charter, when it comes to the powers of the county executive has the power to correct errors with the assessment process. Sean Smith testified that the county counselor, who is David Kavinsky, argued with him during a public hearing that this resolution was illegal and urged him and the other Jackson County legislators not to pass it. Sean Smith also stated that after this resolution was passed, the county executive did not take any action on these issues. He stated that Frank White was largely absent in the summer of 2023 and did not do anything about the 2023 property tax assessments. Now he's talking, so on the second resolution that they passed, he stated that the second resolution expressed an intent from the Jackson County legislature to set aside 2023 property tax assessments. And he stated that they were basically stating that this resolution was about holding future payments from Tyler Technology until they corrected the errors of the assessment, and that this was passed unanimously. The third resolution that he goes into detail that they passed was an intent from the Jackson County legislature to request the Board of Equalization to issue an equalization order to set aside the 2023 property valuation, or to set caps on the 2023 property tax assessment. This resolution talked about the challenges with the assessed values, and it was a request for the Board of Equalization to take a broader action to set aside the 2023 property tax assessments, or to specifically set caps. And this would be taken through an equalization order. And Sean testified that he believed that this would have been the appropriate remedy. Now, the Board of Equalization does have the power to do this, but as we all know, they did not do it. And the fourth resolution that he passed and the Jackson County Legislature passed was a resolution from the Jackson County Legislature where they requested the state auditor to investigate the 2023 property tax assessment. Sean Smith stated that he wanted the state auditor to investigate in order to have the state audit to provide independent and objective opinion. After this resolution was passed, that is when the state auditor got involved with the 2023 property tax assessments. So after that testimony, Sean Smith left the witness stand because the county's office did not cross-examine him, and so he was allowed to get off the witness stand. But he's most likely going to have to go back to the witness stand on trial day 3 because the county might call him as a witness, but direct examination only. So the next witness that the state calls is Zach Walker. And Zach Walker is the city manager of the city of Independence, and he's responsible for administering and managing the city's budget. And so I believe that the reason why he was called as a witness is he's supposed to provide insight as to his experience with the 2023 property tax assessments, but also the impact that the 2023 property tax assessments had on municipalities specifically. He testified that he works with the Jackson County Assessment Department in order to set the City of Independence levy, their tax levy, properly, and that he was the city manager during the 2019 and 2023 property tax assessments. So Zach Walker goes into detail about the 2023 assessment process. And please listen to this because I thought this was interesting. Zach Walker testified that in 2020, okay, you're hearing that correct, 2020, an email was sent to the mayor and city council by Jackson County that there was going to be large increases in property values in 2023, okay? So he's basically stating that the county knew that they were going to do this since 2020. Zach Walker testified that the challenges of the 2023 assessment came in the fall of 2023. He stated that at this time, there were still appeals pending in the Board of Equalization, and that the City of Independence, not knowing what the real assessed value was going to be, hurt them because they were unable to, 1, set their levy correctly, but 2, it made it difficult for them to set the budget because they didn't know exactly what their budget was going to be. And finally, 3, it was hard for them to make accurate planning ahead for the fiscal year due to the uncertain nature of the 2023 property tax assessment. Zach Walker also testified that the canceled Board of Equalization hearings has hurt the municipality of Independence. It has created even more uncertainty because they still don't know what their actual revenue is going to be in their budget. And he also testified that his constituents in Independence would tell him their concerns and that they would state their concern. And when he's saying they, he means him and the city council and the mayor of Independence would state their concerns to the Independence Board of Equalization appointee. And that after this was done initially, they decided to file a lawsuit against the Jackson County government because they felt like their concerns weren't being heard. And so the state brought up the lawsuit that the City of Independence filed against Jackson County. And in the lawsuit, the judge concluded that Jackson County did in fact violate the statutes. So the judge made this finding of fact. However, the judge still dismissed the case because the city of Independence lacked standing, meaning that the city of Independence was unable to have this lawsuit. That's why this current lawsuit that we're in right now against the state AGs, that the state AG filed against the Jackson County government is so important, because the state of Missouri does have standing pursuant to the statutes to sue the Jackson County government over a failure to have a correct 2023 property tax assessment. Zach Walker also testified that the 2023 had an impact on setting the current budget. He stated that if the assessment is reversed, then the cities would have to reduce and adjust their budget, and that would have significant implications for their city. They stated that they might have to cut staff and services for Independence. Zach Walker also stated that if the 2023 property value assessments were set back, then property owners would have to possibly pay more taxes due to the levy. Now, this doesn't apply to Kansas City, but it definitely applies to cities outside of Kansas City, where the levy is going to be adjusted each year due to the assessed value increasing, right? So if a municipality has their assessed value increased with their properties, they're going to reduce the tax levy, because they can only get a set amount of taxes from their property owners. But they said if this is set back, then they'll actually have to pay more, because the tax levy would have to be increased due to the adjustment. So like the levy would be set at a higher rate in order to recoup the cost lost from lowering the levy in 2023. And Zach Walker also states that new construction is one of the ways to raise the level of the assessed valuations. So this is going to the new construction argument. So in Jackson County, or actually in the state of Missouri, say you have a blank parcel, and that parcel, let's just say it's worth $5,000 as a vacated land, right? But say a person wants to build a building on the parcel, the owner would then get a permit from the city signifying that, hey, there's going to be new construction on this land. And so the department would come out and evaluate that land based on its value as a new construction. And so it would not be assessed that year as vacated land, but it would be assessed as new construction. And so its value would be significantly higher than being vacant land. And so what Zach Walker was talking about is if the 2023 property taxes were set back, then the permits that were issued due to they would lose the revenue that they would make from the new construction that occurred on the vacant lands. Because, like, say instead of evaluating a newly constructed building that had a value worth of $100,000, instead of valuating that building at $100,000, they would have to evaluate the value that it was the year before when it was a vacated lot, which would be, say like $5,000, and that would hurt their city, because they would be unable to get the tax revenue for that parcel that year. So I got a comment from Christine Taylor Butler where she stated they can appeal this year, but the deadline's in a few days. So the deadline for an appeal, but and just to make a clarification, these appeals are only for people who have not appealed at all. Okay. So if you haven't appealed at all, you can make this appeal to the State Tax Commission. That deadline, I believe, is July the 8th, but don't take my word for that. I believe it's July the 8th, but please, if this applies to you, go to the State Tax Commission website and verify what that deadline is. So the next witness in this case was Larry Waits. And we're now getting to the series of witnesses that are Jackson County property owners that were telling the judge what their experiences were as a property owner getting the assessments, and what they had to go through. So Larry Waits is a Jackson County resident and a property owner of 3 parcels. And he explains how his house is situated where there's a house and there's 2 parcels of vacant property surrounding his house. And he stated that the property value assessment on one parcel, and this is the parcel with the house on it, went from $70,000 to a figure that was above $200,000. Larry Waits appealed each parcel, and he stated that there's no evidence that anyone came to his house to inspect the properties, and that he received a notice of review. So that means he received a notice of an informal hearing on July 10th and had his informal review. So Larry Waits, in his testimony, went into detail about his review process. And before I go into this, I need to state that Larry Waits has a wife there with him that's wheelchair bound. And so he was going into the fact that how difficult it was for him and his wife to attend these hearings, especially due to the fact that his wife has to attend these hearings in a wheelchair. He stated that he had to wait, him and his wife had to wait all day in order to have his informal review, and that the building was packed with people and it was generally uncomfortable. He stated that when the informal review started, that he brought information of his properties to the hearing officer, which included photos of the disrepair to the property, but they were unable to get a resolution, and the county did not have at that informal hearing, the county did not have any information of the 2 other parcels in his property, and that since they did not have the information of the 2 other parcels, that they had to leave the informal hearing and come back at a later date. Larry testified that he made a sunshine law request to see the information that the county used in order to make their 2023 property valuation or assessment valuation. And all of the properties that the county used in order to determine his property were lower than his assessed value, which to me was wild. Larry stated that he requested the hearing officer to use those lower values, and the hearing officer refused to use their lower values in order to assess his property. He did not receive a resolution on that day either. He made 3 sunshine law requests and did not receive any information from the county. Larry stated that the hearing officers refused to use the comparables that he provided to them, and that he's still currently actively appealing his property. So he also viewed his 2023 reassessment notice, but he stated that he received it after June 15th, and that he hasn't had his BOE hearing because they canceled his BOE hearing. Larry also stated that he appealed to the state tax commission as well, but they've only had a conversation on the phone, and that there was no resolution, and that the whole process was a general mess. He also stated that he currently doesn't know if his state tax, like what the status of his state tax commission appeal is, and he doesn't know if it was dismissed or not. And he hasn't heard anything from the state tax commission, and he hasn't heard anything from the BOE, which just kind of goes into that argument that the state is arguing regarding the dysfunctional nature of the appeal process. Because if we have all these people that are appealing, that are getting their hearings canceled by the BOE, that are having trouble with their hearings with the state tax commission, and they don't know what the status of their case is, when in fact their cases were dismissed a while ago, but they still don't know, that's a huge problem. And that is a violation of due process, aka their rights to appeal and have a hearing on their property. Yeah, I just read the comment by Judy Jackson. I'm sorry to hear that. That's your story is like a similar story to what a lot of people in Jackson County suffered through in this 2023 property tax assessment. The next witness that was called to the stand was a witness by the name of Mary West. Mary West, and this was very interesting because Mary West actually worked at the Jackson County Courthouse, okay, and is a Jackson County resident. She owns a home in Jackson County, and she also contested her 2023 property tax assessment. Mary West's property was valued in 2022 as $258,000, but it was increased to $670,000 in 2023. Mary testified that she did not do any improvements to her house, and that she appealed the property tax assessment, and she met with the assessment department for her informal hearing on July 31st, 2023. But she's basically stated that she also too made a sunshine law request. And on her first request, the county stated they had nothing in their file. But then she made another sunshine law request in February 2024, okay? And the county again stated that they had no documentation of her property in their file. Now, remember the judge's question, okay? When the judge was reviewing an example of the evidence that would be provided that a physical inspection occurred, and that one of the pieces of evidence that was used was a photograph. But if we have all these properties that the county has absolutely no evidence whatsoever to prove whether a physical inspection occurred on the premises or not, that is a huge problem. That means that the county assessor did not meet the requirements she needed to meet pursuant to Chapter 137.115 in order to prove that she did a physical inspection on that property. But let's continue. So Mary West stated that in order to appeal her property tax assessment, that she provided her own comps, photos, and other documentation. She stated that her hearing was a fiasco and that the hearing officer was extremely unfriendly. She basically stated that the hearing officer the hearing officer told her that she refused a physical inspection, okay? And Mary told the hearing officer that that didn't happen, that no one came to her property or called her or asked her for a physical inspection. And this goes into the other point that there's no evidence of, the county communicating that a physical inspection needs to occur or that a person refused to, because in order for them to have that information, they would need the name of the inspector and the date of the refusal, right? But they don't have that information. But at this hearing, the hearing officer stated that she refused a physical inspection, even though they don't have evidence that she in fact refused the physical inspection. And I'll say this, her testimony was very persuasive because the county did not put on any evidence to suggest otherwise, okay? But next, the hearing officer at her hearing showed comps of property values that were, this was crazy. So she testified that the hearing officer was showing her comps of other properties in her neighborhood that were currently listed but not sold, and stated that this was indicative of the true value of her property, which she said didn't work because these are the current listings. These aren't the prices where people actually purchase this property. So we don't know. You can't use this value as an indicator what the current market value of the property is, which Mary, in my opinion, is completely correct on this point. Mary testified that she eventually settled on a valuation of $495. She stated that she also relied on information provided by Facebook groups, like Jackson County property tax assessments, in order to help her through the process. She also stated that this settlement happened when she appealed to the state tax commission in December. She stated that when she appealed to the state tax commission in December, her case was heard in April. And she stated that the county attorneys were arguing that since she did not have the Board of Equalization appeal, that they would move to dismiss her case. But Mary then decided that she would accept the value of the $495 instead of having them dismiss her case. And she stated that she was generally satisfied with the resolution. But that testimony, in my opinion, is very problematic because that shows a level of coercion when it comes to accepting these resolutions, right? And also, remember, if you saw my prior video, the county argued to the Supreme Court that they admitted that their process was unfair, but they stated that it wasn't a fatal flaw in due process because they could still appeal to the state tax commission. Then after that happened, and the Supreme Court used that rationale to say, well, there isn't a true violation of due process because these property owners still can get redress through or remedy through the state tax commission. But then after that hearing took place and the Supreme Court ruling was issued, the county assessor went to the state tax commission and argued hundreds of cases saying that they needed to be dismissed in the state tax commission level because they did not go through the proper avenues of appealing through the BOE first. And this is another example of them using this argument to dismiss this case, even though they told the Supreme Court allegedly that they wouldn't do so. The next witness was a man by the name of Glenn Meyershaven. I'm probably saying his name wrong, but and I'm probably spelling it wrong, but that was the best that I could do. Now, Glenn is a Jackson County resident that owns property in Jackson County and appealed his valued assessment. In 2022, his assessed value was $229,000, and I believe, yes, his assessed value in 2023 was a figure of above $500,000. I believe I have it there as $560,000. Glenn stated that he made no improvements to his property and that his property needed repairs. He appealed the assessed value, and the county gave him an informal time a time for his informal review. Glenn stated that he was unable to make it to the time, and I believe this was due to a surgery he needed to have. And he asked for his informal to be rescheduled. And this is the thing. After he asked for that, he hasn't heard anything else from Jackson County. So for almost over a year, Glenn has been in limbo. He hasn't had an informal hearing. He hasn't been able to have an informal or a formal hearing with his property taxes or about his property assessment. Glenn also went into a lot of detail about how hard it was to use the Jackson County electronic system to file his appeal, and how hard it would be for elderly people in general to use the electronic system that the Jackson County government had to file their appeals. He stated that he had issues when he tried to upload the documents multiple times, that the site was crashing, and that he was ultimately he was unable to upload those documents. Glenn basically stated that after he made the request for his informal hearing to be rescheduled, that nothing else has happened on his property, that he hasn't heard anything from the county, and stated that his mortgage payments have increased by over $1,000 per month, and that this has created a severe hardship in his life. He stated that he has zero confidence in the assessment process and doesn't even believe that they looked at his property. And he's talking about the physical exterior inspections. So now during the cross-examinations, oh yeah, this was great. During the cross-examinations, the county attorney provided Glenn with a document. So basically, when the state AG office was interviewing potential witnesses to call on the stand for this case, the AG had them fill, and I shouldn't say them fill out. They had a person call them, and a secretary would write down their answers of a questionnaire on a form about what their general testimony is, what happened during their process. And the county defense attorneys were using this to show that, oh, this guy is actually technologically savvy. He can actually do all these processes. He's just, he's just essentially, his testimony that he wasn't tech savvy enough to do this is unreliable. But Glenn actually did a good job with counteracting that. He stated that first, he did not fill out that questionnaire, that it was somebody else. It was the secretary that filled out that questionnaire. And also, he stated that the AG's form, and he's talking about the online form that he filled out to be interviewed by the AG, was actually easier to fill out, and that the state AG's webpage was way easier to navigate than the county's online appeal form. Glenn also stated that he believes that the appeals were biased and against elderly people because the county knew that they were not computer savvy and that they were prone to have multiple issues when it comes to online filing. Glenn also stated that he believed that his property value should be valued at $300,000 and ultimately agreed that his value needed to be raised, which I find that Glenn's testimony was basically showcasing, the average opinion of a Jackson County resident, where Jackson County residents, they aren't mad that their property tax increased or that they didn't believe that their property value should have been increased at all. Jackson County residents are okay with their property values increasing. They just want the process to be fair. And what Jackson County did with their property tax assessments by using invalid comps, by making the process impossible for the average Jackson County resident to actually go through in order to have a fair assessment performed on their property, basically shows that this 2023 property valuation needs to be overturned. It's not a problem with the Jackson County residents. It's a problem with the property assessment itself. And I think Glenn's testimony was really great showcasing that point. So the next witness was a person named Shirley Jenkins. Shirley Jenkins is a lady who's 80 years old, a Jackson County resident, and a property owner. She appealed her assessment, and she stated that she didn't receive actually anything in the mail, but she actually filed the appeal because of the news reports that were coming out, and her daughter telling her that she needed to appeal due to these news reports. So she didn't even receive the 2023 reassessment notice. So Shirley Jenkins basically stated that she went to the informal review and that her hearing officer, again, was Kennedy Jones. Okay. Remember this. This is important. Kennedy Jones is the guy who testified in day one about how Tyler Technologies used invalid comps in order to make these assessments, invalid assessments. Okay. So Kennedy Jones was her hearing officer. And basically, when Kennedy Jones reviewed her information, he stated that that her property was actually valued at $325. But Shirley still didn't agree with Kennedy Jones, and so no resolution was made. So she decided to continue with the process. So she applied to have a formal hearing with the Board of Equalization. However, she was notified that her Board of Equalization date was canceled. Remember, the Board of Equalization hearings, they have been suspended, and right now they're having minimal hearings. So Shirley Jenkins said that her hearing date was canceled and it's still not been rescheduled, and that she had to reach out to the Board of Equalizations on multiple occasions to attempt to reschedule the hearing. She stated that when she reached out to the Board of Equalization, a person named Miss Davidson contacted her, and she was unsure who Miss Davidson was, but she later found out that she was actually another hearing officer with the Board of Equalization. So Shirley Jackson testified that Miss Davidson took Kennedy Jones' valuation and increased it from $325 to $361, and stated that she should settle for the value of $361. So they took Kennedy Jones' evaluation of $325 and then she basically said, actually, Kennedy Jones' valuation was incorrect. Your property's assessed value should actually be $361. And Shirley Jenkins basically testified that there was no interior inspection done, and she's unsure as to whether a physical exterior inspection happened, and she still has not received a resolution, and that currently she is paying over $300 per month on her mortgage. The next witness that was called to the stand is a Jackson County property owner named Linda Poole. She is 75 years old, and she has a property in Lone Jack, Missouri. In 2022, her property was assessed at $360,000, I believe. Or sorry, $303,000. And it was increased to $925,000. Just let that sit to you, or sit with you. Sorry. Of course, she filed an appeal, and she had 3 informal hearings with the county. Now, this is significant because, again, we're talking about multiple informal hearings before actually having a formal hearing with the Board of Equalization. So she had to go through all these informals, and she still hasn't had her formal Board of Equalization hearing. Linda stated that her first formal hearing, in her first informal hearing, the officer lowered the value, but she believed that the value was not lowered enough. She stated that the county never provided any documentation to show that they did a physical inspection on her property. Linda stated that her properties has increased from $4,000 per year to $12,000 per year, which she has to pay now because this whole appeal process is still ongoing. So she's still liable for those payments. Linda states that she received a 2023 reassessment notice and had a meeting with the Board of Equalization last week. Okay. Now let me go into this hearing that she had, because when her testimony was, when they kept on asking her more questions, she was unsure whether it was the Board of Equalization or whether it was the State Tax Commission, which is a huge issue because this shows the dysfunction of the process, because she didn't know that if this was pertaining to her State Tax Commission appeal or her Board of Equalization appeal. So she stated that she didn't know if it was a Board of Equalization or the State Tax Commission. She stated that a person called her on the phone and asked her, and this is like 2 weeks ago. So she's saying that this call happened 2 weeks ago. They asked her if they could do a physical inspection of the property. Okay, just let that sit with you. They called her 2 weeks ago and asked her if they could do a physical inspection of the property. Meaning, it's implied possibly the county doesn't have any information of this property, because do they have evidence that a physical inspection that actually occurred in 2023? You would think that if they did, they would be using that information in her hearings. But according to Linda, they called her 2 weeks ago to ask her to do a physical, and this isn't even interior, this is an exterior inspection on her property. During the cross-examination, now this to me was wild. During the cross-examination, the county's attorneys basically handed Linda a piece of paper that stated that her State Tax Commission appeal was dismissed, and Linda didn't know. And then it spun into this whole confusion because she was like, what do you mean it was dismissed? I didn't dismiss anything. What do you mean? Which goes again into the dysfunction of the process. But Linda then stated that she believes that this dismissal applied to her 1.1 acres and not to her 21 acre lot out in Lone Jack. But as of the time of this live, we really don't know. Okay. But that was the county's cross, is to show her that her property was her appeal with the State Tax Commission could have possibly been dismissed, which to me is wild. The next witness was Dorothy Vandergen. And Dorothy said that her the assessed value from her house increased from $251,000 to $415,000. She stated that she had an appraiser come out, and that appraiser agreed that her home was valued at the correct value of her home was $250,000, but admitted that the appraiser was her friend. Dorothy still has not resolved her appeal, and it's still pending. Dorothy stated that her tax bill has increased from $2,300 to $5,100. And she states that she is retired and she's unable to pay the additional taxes and will be forced to sell her house. And she stated that her appeal wasn't just because she believed that they improperly valued her property, but she also stated that she believed that she was also targeted because of her age and disability. And she went into testimony about how the process was harder for elderly people and disabled people to continue in order to get correct valuations of their properties. Now, the final witness of day 2 was an individual named Todd Schuler. And his testimony is actually very important because it goes straight into whether the Jackson County 2023 property tax assessments comply with the state statutes. So Todd Schuler is the audit manager for the state auditor's office and works for the Kansas City office downtown. In general, he audits counties, cities, towns, villages, and also he conducts the audit for the state of Missouri every year. Todd states that he's responsible for multiple audits. He oversees constantly 1 to 3 audit crews that works on audits all around the state of Missouri, and that he generally performs what he calls as performance audits. So I'm going to pull up this document for you again. So the reason why Todd is being is on the stand right now because they're going to ask him about this auditor's report here. But let's continue. So he details what a performance audit is. He states that he uses 3 objectives in this performance audit. He states that he reviews the internal controls, second, the legal compliance, and 3, he reviews the internal management practices when he performs these performance audits. He states that the state auditor's office got involved because they received the request from the Jackson County legislature to do an audit of the 2023 property tax assessment. And he states that that once the request was accepted, that they actually started the audit process in September 2023, and that he was personally involved in this audit, and he's also still involved in this audit. And he testified that in December, the auditor's office sent out a preliminary letter to the county, which this is, like I said, right here. This is the preliminary letter that he's referring to. He stated that this was an extraordinary situation, that in his tenure at the state auditor's office, which he testified that he's been working with the state auditor for 30 years, that he has never put out a preliminary letter, but he felt that it was very important in this case. And he states that preliminary letters are sent out if they uncovered a very insignificant non-compliance and that it's time sensitive. And he stated that they did uncover multiple significant non-compliances and that the time sensitivity dealt with the tax bills coming due at the end of the year. And so that's why they felt compelled to issue this preliminary letter. Todd stated that there were numerous complaints regarding the assessment process of 2023. These complaints, and when he's talking about the complaints, he's not talking about the complaints from the constituents. He's talking about the what he witnessed as to the process. He stated that there were complaints in the auditor's office of the notices, the processes, and the procedures of the assessment. Todd stated that they requested the county to provide them information regarding the notices given to taxpayers. And he testified that the county provided the auditor with the 2 different notices given to property owners. And we're going back to this. What he's referring to is this notice right here that was supposed to be sent out to every single property owner whose assessed value increased by over 15%. And this notice right here, the 2023 reassessment notice, which is the official reassessment notice that usually is sent, that has a deadline to be sent out on June 15th. Oh, actually, let me pull this back up because I'm going to be going through this, okay? So Todd stated that the assessment department found that over 200. So remember, Jackson County has approximately 300,000 parcels, okay? Todd stated that the assessor's department found that over 200,000 parcels had their assessed values increased by over 15%. 200. That means 2/3 of the properties in Jackson County in 2023 had their property values increased by over 15%. And Todd stated that only 50,000 letters, and what he's referring to, is this letter right here. So this is the first notice that they needed to send out to property owners stating that their assessed property increased by over 15%, that they were going to give them notice that a physical inspection was going to occur, and that if they wanted to, they could request that a physical and interior inspection also be performed. And that's supposed to be sent out 30 days. They're supposed to give them a 30 days notice. But he stated that only 50,000 letters, and this is the letter, were sent out in April through June, and the county ran out of time to submit the last 150,000 letters of the first notice. Todd also states that 25% of properties whose assessed value increased by over 15% actually received notices of their assessed values increasing by over 15%. But he stated that a large number of the notices were undated. And he also stated that the notice that I have on my screen was also improper for the reasons that I stated before. But one thing I'll point out to you, just as a reminder, it has to provide you notice that your assessed value is increased by over 15%. Where in this letter does it state assessed value? It doesn't. It states market value. So on this letter, it has no information on how much a person's assessed value actually increased by. So on that point, it was improper. But let me continue. Todd stated that, here we're going to get into it. He stated that the first notice lacked information of the assessed value. Todd stated that the county did not provide notice to the property owners of the assessed value increase, that a physical inspection is required, and that they have a right to a physical inspection. So these are the door hangers, and this is what Todd's talking about in this section. Todd states that both the door hangers and the first notice of increase, so that's the door hanger, and this is the first notice of increase in property values, did not have these requirements, okay? And the requirements, again, is that it did not show that a person's assessed value increased by over 15%. It did not give them notice that a physical inspection would be required and happen. And third, it did not provide them notice of a right to an interior inspection. He also stated that they had to perform the interior inspection within 30 days, and that was not included in the first notice or this door hanger. He also stated that the door hanger and the first notice does not state the name, date, time, and extent of the physical inspection, so that both of these were improper. And Todd states that the assessor's office merely stating that they perform the physical exterior inspection is not enough. I repeat, is not enough to establish that a physical exterior inspection was completed. So he basically states that when and please, if you haven't seen my first video, please watch it because I break down the complaint. But basically, when you appeal your property taxes, your property tax assessment, the burden is first on the assessment department in order to show that the assessed value that they assessed your property at was legal and complied with state statutes. They're supposed to show that first. And then once the BOE makes the determination that they've met their burden, that they showed that their assessed value is legally compliant with the state statutes, right? How they came up with the values, that they did all the steps correctly in order to have that assessed value. Once they prove that, then the property owner is supposed to put on evidence to show that the assessed value is actually incorrect. And we have here Todd from the auditor's office stating that the assessor's department merely stating that they performed the physical exterior inspection was not enough to establish that a physical exterior inspection was completed. And the reason is there's no evidence of this. Next, now we're on the impact notice, which is this one. Sorry, I'm just making sure. Yes, that's the impact. The impact notices are the reassessment notices. Todd stated that the impact notices that were mailed out on June 15th did not provide sufficient time to property owners to reach out to the county to receive a physical exterior and interior inspections. Todd also stated that the notices were inaccurate and untimely. And I'm sorry, I'm experiencing a little bit of lag here, but bear with me for a second. So yeah, he basically stated that these were untimely. One of the arguments that he states is he believed that this is untimely because of the fact that a property owner has a right to request an interior inspection, and that interior inspection has to be completed within 30 days of the request. Now, if they sent out this 2023 reassessment, and also just to state clearly, that right is only for property owners who had their assessed value increased by over 15%. If that property owner had their reassessment notice mailed out to them on June 15th, and let's say hypothetically they received it on June 19th, that would not be enough time for them to request the physical and interior inspection, get the information, or have that physical and interior inspection completed, and get that information together in order to make a determination whether or not they should appeal the assessed values. And that's why he believes that the June 15th notices did not provide sufficient time for property owners to actually do this process properly. Todd finally stated that the final report of the audit will be released, but it might be released either in late winter of 2024 or the spring of 2025. So that basically concludes the day 1 and day 2 of the trial. The next trial date is July 8th. And the two last witnesses that the state's going to call to the stand is Preston Smith and Gail McCain Beatty. Preston was supposed to testify on June the 28th, but of course the county attorneys objected because they wanted time to depose his PowerPoints. So during this week, the deposition is going to occur, and they're going to call him first to the stand on July 8th. And so then after Preston Smith and Gail McCain Beatty, who is the county assessor, testifies, then it will be the county's case, which I heard the county only has 2 witnesses, but I'm unsure. Like, don't take that for fact. I really don't know how many witnesses the county has, but I will definitely be there. I will definitely be continuing to live tweet to provide live updates of this trial on July 8th. If you want to see the live updates, just follow me on Twitter or go to my Twitter account, which is also Stacey Lake MO. And right now, if you have any questions that you want to ask me, this is the perfect time to ask me questions, because this concludes my Let's Talk Jackson presentation. So if you have any questions, please let me know. And if not, in the next 30 seconds, I'm just going to log off. But yeah, this trial for me is very enlightening. Like I said, I'm not going to provide my opinion as to, my opinion as to the state AG's attorneys or the county attorneys until after the court rests. But I have, and I will restate this for everyone, provided my opinion of the judge. I believe that the judge is reasonable, that she's making great level-headed decisions, and I honestly believe that she's going to whatever her decision is going to be, I believe it's going to be a decision that is going to be based upon facts and the law. So Dana asks, does a physical drive-by count as the physical inspection? No, it does not. And in fact, in statute, in the statute 137.115, it specifically states in that statute that a drive-by is not a physical inspection. And so, as I stated earlier, when a physical inspection occurs, they have to provide information of one, who was the person who conducted the physical inspection, the date and time of the physical inspection, the extent of the physical inspection, and what they actually did. And there isn't any evidence on the majority of these parcels that actually occurred. James Roger asks, how much is it even possible that these numbers cannot be thrown out, or how is it even possible these numbers cannot be thrown out? The county, I believe, and I will get into this after they rest their case, but I believe they're going into a whole argument that setting aside the 2023 property tax assessments is going to create more harm than it is going to create remedy, and the extreme amount of harm that it's going to create to the county and with the schools makes it so that the judge should just say, hey, I know that they violated the statute, but I'm not going to reverse the 2023 property tax assessments because it would cause too much harm to the county itself. I believe that that's the approach that the county defendants are going to use. Kevin asked, will it continue in Clay or Jackson County? It will continue in Jackson County. Lisa asked, so a picture with a date and time stamp is not sufficient? Yes. That's what the state witnesses, who are people from the State Tax Commission and the State Auditor's Office, are saying right now. Thank you, Dana. And then Lynn asks, if it's found that the 2023 tax assessments were not legal, the resolution should not affect the possible consequences to Jackson County. Levy budgets could have been planned on previous tax assessments since they knew that there were issues with the 2023 tax assessments. In other words, the windfall in the taxes was being contested, and they should have then adjusted the school budgets. Yes, that is an argument, but that's what the judge will have to consider. But that is an argument that the state can state on their side. And also the whole argument that they were trying to get with Zach Walker, the city manager of Independence, about how they have to tweak their budgets and stuff, also shows that this is probably one of the arguments that the county is going to focus on is that recalling the property tax assessments is going to create more harm. And they might even do something crazy by saying that, hey, if we reset this, like Zach said, the levy is going to be increased. So in fact, the property owners are going to pay more taxes because they'll have to increase the levy, which I think is wild, because if people got their property taxes increased by 100, 200, 300, 400%, a property levy increased by like 4 to 5% is not going to outweigh, their unjust assessed values. James Rogers says, so in that case, it's taxation without representation. James, if you're interested, I did do a presentation last week going through the petition, where they make a lot of arguments citing to the Missouri Constitution, section number 10, which is all about taxes. So yes, essentially. Karen says, why are we getting information for senior to go for information to freeze their tax when this hasn't been resolved? I tell people, if you qualify for the senior tax, do it now, because if this 2023 property tax assessment gets reversed, I believe that they will apply that cap to the 2022 levels and not keep you at the 2023 levels. Because if the judge finds the 2023 levels void, they're going to order whatever they stated the 2022 levels were to be applied to the 2023s. And so that's why, if you are able to get your taxes frozen, apply now, because if the 2023 levels are founded as void, I believe that they will automatically freeze your taxes at the 2022 levels once you're accepted into that program. Fawn states, well, the county intentionally chose not to follow statutes, so why should the taxpayers have to be penalized financially because the county don't want to call harm to the school districts and county? This is all up to the judge, okay? And also, I want people to know that whatever the judge's decision is going to be, this case is definitely going to be appealed to the Western District. And I shouldn't say it's definitely, because I don't see the future, but I believe that whatever the judge is going to rule, they're going to appeal it to the Western District, and they're going to appeal it to the Supreme Court of Missouri. And at the end of the day, the only redress that we have as a collective community of Jackson County is through the judges right now. So the whole thing of why should the taxpayers have to be penalized financially? The taxpayers shouldn't have to be penalized financially, but the courts could basically make the determination that, yes, this was messed up. Yes, people are suffering from overtaxation. However, they still had, all these different remedies, and there would still be way more harm caused to the government if we recalled all of this and blah, 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 even if the process on face was completely unlawful. That there's still a possibility of that, okay? But what I'm saying right now is we do have an immense possibility right now to get the 2023 property tax assessments completely voided as well. Yes, seniors do have until December 31st, 2024 file, but like we have seen with anything could happen, man. Like if you, for instance, start the filing process in November, it might not get accepted until later on, and there might be an error with your filings. So that's why I'm telling people to file right now. Make sure that you get accepted into this program right now when you have plenty of time. Do not wait until the judge makes the decision on this case to file before you file. Because I'm telling you, if the judge finds a 2023 property tax assessment to be improper and voids them out, your property taxes aren't going to be frozen at the 2023 level. They're going to adjust it to what the 2022 levels were. So if you have that concern, and of course, this isn't legal advice, but this is just what I'm saying is like what's going to happen, because the judge possibly could void out the 2023 property tax assessments. If she finds those as void, they're going to apply the 2022s to the seniors, in my belief, to that freeze and not the 2023s. No problem. Does anybody else have any other questions? Okay, well, with that said, I'm going to conclude today's Let's Talk Jackson. Thank you so much for watching. If you haven't, you can follow my pages, but also share this video if you can, because I think every Jackson County resident that owns a property needs to know and needs to have access to the information of what's going on in this trial, because the implications of what's going on in this trial is going to have an effect to every single Jackson County property owner, and therefore people should have access to what's going on in this case. Sorry, I'm looking at Fawn's comment. They said they aren't going to even, sorry. I know, Fawn, but still apply. Please just still apply, regardless. Okay. Anyways, I hope you guys had a nice time listening to this podcast, and I hope you guys have a great rest of the Sunday evening and have a great and safe 4th of July. I will be doing another podcast going over the July 8th trial, and also going into what I believe my own personal opinions are as to the state's case and the county's defense after the court rest. So please tune in, because that's going to be, I think it will be very informative as well. Betty asks, can Frank White or Jel McCain Beatty be fired over this? Do jail time or be fined? The only person that can fire Gail is Frank White. And I mean, this is a civil issue. This isn't a criminal issue. If they find criminal impropriety, there could be a case filed against them. But this case is just pure civil case. It's not a criminal case. So they cannot, with this case, they're not going to have any criminal ramifications, and they're not going to be fined. And that's the thing that kind of makes me a little bit sad about this whole situation, is who is paying for all of this whole mess? Who's paying the $17.9 million to Tyler Technology to do this 2023 property tax assessment? It's not Frank White. It's not Gail. It's us. I mean, can we actually just think about that for a second? We gave Tyler Technologies $17.9 million to do this. And this is what happened. Instead of investing this into our county, instead of investing this into our assessment department, so we can have these internal, so we could have this process done internally and have full control over our assessment department, we allowed it. And when I say we, I don't just mean the Jackson County executive. The Jackson County legislature also had to vote on this, and they voted to give Tyler Technologies $17.9 million to do this. So the Jackson County legislature is also directly responsible for this 2023 property tax assessment. They allowed this to happen, and we're the ones that will have to suffer with the ramifications of this action, because, you know, they're using our money to do this. And no, this case is not going to get Gail or Frank fined. This case is not going to get Gail or Frank, a prison sentence. This is a purely civil matter. And so the only redress that we can ask for the court is the redress that the state is asking for. And one of them is to void out the 2023 property tax assessments, which I hope happens, but I can't guarantee what's going to happen until the judge issues her final order. And so with that said, again, have a great 4th of July weekend. Be safe, and I will see you next time.